Mani perhaps implies that it could be both instances. Could be a civil declaration, it could be a conviction also, which would both be covered under 61F.
It just raises questions, valid questions.
Yes.
One judge gives an opinion.
That's right.
And said these cannot be decided.
जी बिल्कुल justiciable नहीं है.
No, but at least Samullah does this, that it addresses the question as to what declaration it would be, and they said it's a declaration coming out of civil.
So that again, the Samullah overlooks that the 7-member bench actually contemplated perhaps both. The 7-member bench said also
but
part
to one
of
extent, I mean, to civil only they've come up with some answer.
A part of A that they say that जहाँ पे कोर्ट का बताना था तो उन्होंने कहा कि civil होगा. It did not then hold that why not a conviction.
And उसमें भी problem ये है फिर तो अगर if we are so then we stuck on the very basic question कि declaration from a court of competent law क्या है.
That's right, sir.
So
that has to be answered.
So that's not answered.
Yes.
So बाकी सारी चीजें तो दूर की बात है ना कि duration क्या है.
Everything is based on that premise that there is a declaration by a court of law and we don't know.
So we're assuming on Samullah's argument that there is a declaration which would be between inter-parties arising out of civil jurisdiction, and then as a consequence we'll build into it that the person is non-honest.
What would be the effect of that declaration
and effect we'll say
the consequence and so on, and then
I will go another way. I will say I cannot bring myself to disagree with Justice Khosa.
That was a very profound
what we have read. Can I not say that? I cannot bring myself to disagree with Justice Khosa.
Could my lord, yes.
He's a 7-member bench member. The others have not disagreed with him. They should have said, we don't agree, this is a dissent you're writing. You're not writing an opinion of the court.
So where does that leave us, Samir?
So, my lord, now I think as a first step, in my respectful submission, as a first step, my lord would have to first hold what court would it be or what courts would it be, civil or criminal, either or both, which would give this sort of declaration for the purpose of 62(1)(f)(1). What would be the procedure which will have to be adopted for the purpose of that declaration? What is the standard of proof which would be required, both, and then the locus standi?
In Khakwani, the High Court refused to interfere. High Court refused to interfere
Actually, this
for the reason that the High Court cannot go into such.
आ जाती है. इतने दिनों से हम ये सोच रहे हैं कि कैसे करें. आपके ख्याल में रिटर्निंग ऑफिसर समझ लेगा बात को या आम शहरी समझ लेगा?
मैं अभी आगे आता हूं.
जो खोसा साहब की बात है मुझे तो बड़ी भारी बात लग रही है. उसमें मुझे कोई आई एम ट्राइंग टू इन माय माइंड ट्राइंग टू disagree with it, and I can't bring myself to disagree with it. He's saying you cannot give these declarations full stop. So maybe these are just rhetorical questions. They don't have an answer. I mean, there are many questions you don't have an answer for. This may be one of them.
इसकी एक interesting बात बताऊं.
However, nonetheless, Parliament has understood 62(1)(f) better than us and has formulated something. Okay, fine, good for you, Parliament. They represent the people of Pakistan. They've understood it, they've done it. Now, unless I can then say Parliament has done something wrong, the only thing Parliament says कि भाई आपके 7-member bench को हमने follow करते हुए ये काम कर दिया है. It is more in tune with the 7-member bench judgment, section 232(2) than Samullah is.
That's right, sir. And मैं थोड़ा सा एक background बताऊं. My lord was originally अभी एक्सप्लेन हुआ कि सिर्फ 3 प्रोविजंस थी, A, B, C था 62 में. When the constitution was being made, certain amendments were proposed by members who belong to religious parties. I'm talking about the original constitution making, at the time of original constitution making. I'll just read out very slowly. I don't have, unfortunately, a copy of it. 2 amendments were proposed and motions were made and they were negatived, they were rejected. And if I may read out, they are quite akin to what was then inserted through revival of Constitution Order 1985 by General.
Where are you reading from? Parliamentary debates?
Parliamentary debates.
Copies दे दीजिएगा मैं.
जी copies दे दूंगा मैं. I'll just slowly read it out. And these were rejected.
What year is this?
This is, my lord, 1973. These are dated 15th of March 1973, sir. So the first amendment which was proposed was he is conversant with the affairs of the country, which is okay. He is conversant with the affairs of the country and is not reputed for his bad character or for contravening the injunctions of Islam. This was rejected by the House. Second, if a Muslim, he is honest, and not an open violator of the dogmas of Islam and possesses the necessary knowledge of his religion. Both were rejected. And while rejecting it, the Speaker said, and I would just quickly read out one paragraph from the proponent of one of these amendments and then the response given by the Speaker.
Who proposed these?
My Lord, these were proposed by Maulana Abdul Haq of Koda Khatak, Maulana Ghulam Ghaus Hazarvi and Maulana Mustafa Al-Azhari. So these were the three members who proposed them and the House rejected them. I just read out, these are very telling passages, what he had in mind and then how the Speaker responded. And this is exactly what Justice Khosa has observed. जनाबे वाला मैंने तरमीम पेश की है कि पार्लियामेंट का जो रुकन हो उसका किरदार, उसका इखलाक, उसका तकवा, उसकी दयानतदारी, इसका मामला शनास होना, इस्लाम के बारे में उसकी बुरी शोहरत ना हो, ये खसूसियात भी लगाई जाएं। असल में इस दफ़ा में ज़ेली तौर से बहुत सी चीज़ें लगाई हैं कि अरकान में इनका होना ज़रूरी है। एहलियत होगी तो मैं अर्ज़ करूं कि ये जो है यानी जो पार्लियामेंट है, पार्लियामेंट जो है वो तमाम मुल्क में बहुत ही अहम इदारा है। इस ऐवान के अरकान हैं, ये आइन बनाने वाले हैं, कानून बनाने वाले और मुल्क के अंदर अदल व इंसाफ कायम करने वाले इदारे के अरकान हैं। इसका जवाब सर Speaker responded, and then obviously it was then later put to vote. He said, आप मुझे इसका जवाब दें कि आपने फतवा दे दिया कि इसकी शोहरत अच्छी है और वो अहल है। दूसरे कई उलमाए कराम ये फतवा देते हैं कि इसकी शोहरत अच्छी नहीं है, इसलिए ये चीज़ इसके मुंतखब करने वाले जो लोग हैं, जो वोटर हैं, उन पर छोड़ी जाती है। अगर वो समझें कि वो अहल है तो वो अहल हो सकता है। And then ultimately it was put to vote and it was rejected. So,
maybe it's a guideline for the voter.
Yes.
Maybe why can't it be considered a guideline for the voter? Maybe you want, it may be not on your radar, but you should consider these points.
Some sort of inspirational standards for future.
D, E, G and precisely are that. Now what happened here? Mr. Uzair Bindari argued and he relied on paragraph 33 of Samiullah where Samiullah Baloch with respect, erroneously relies on Imtiaz Lali case of 2007 to say that pre-18th Amendment, the Supreme Court had disqualified someone for life under 62(1)(f), erroneously. Paragraph 33 refers to Imtiaz Lali, which is PLD 2007, Supreme Court 369, which was incorrect. In Imtiaz Lali case,